Hello everyone, welcome to Court with Krissy. I'm overdue for a small claims court docket, so here are 3 different cases, with my favorite first. I have a feeling that this lady will be sitting in a different type of court for the next 18 years. I hope you like it. Court with Krissy is now in session.
Hand. Do you swear or affirm that the testimony you are about to give in the matter presently before this court to be the truth, the whole truth, and nothing but the truth, and this you do under the penalties of perjury?
I do.
You may be seated. All right, so Ms. Snyder, here's how it's going to work. Here at the beginning, you're now under oath. You're giving sworn testimony to the court for me to consider in deciding your case. I'm going to ask you a couple of questions based upon my review of your claim, and then I'm going to give you all the time you need to talk and give you any time you need to call witnesses or show me documents or do anything else you'd like to, okay? So my first question is this. I reviewed your claim, and it says that you're suing for $3,500, that you're alleging that you loaned Mr. Street that $3,500 so he could purchase a vehicle. Okay. Was that loan made in one payment or in multiple payments?
It was just one payment. Like for me to him was just one payment.
Excuse me, can I get your pen? I left my pen back there. I'm sorry, I had to
No,
get
you're
a pen. Okay, I'm sorry. Could you repeat that for me?
It was just one payment.
One payment of $3,500.
Yes.
When was that made? When was it?
April 22nd.
Of what year?
2020.
All right. So did you and Mr. Street have any written agreement regarding the loan?
It was not written, no.
Okay, so it was all verbal.
Yes.
Tell me what the terms were. So what did you agree to?
I agreed to lend him the $3,500 to purchase a truck.
Okay.
And then he said, we agreed that he would pay me the full amount back by June 22nd. So we agreed to 2 months from that day that he would have the full amount paid to me back.
Okay. And so, did you pay it in cash, by a check, by online, an electronic transfer, or do you have any document showing that you made that payment to him?
I have, do you want like paper copies that I have?
Certainly, and you can just hand them to this lady here.
We just need one set.
Yeah, I just need one. Okay.
And there's one showing the bank statement of me withdrawing the cash.
All right. What I will need to see is the bank statement or a canceled check or something showing that you made the payment.
Did I give you this one? I think that's what sorry.
This is the same one too.
Yeah, okay. Yeah, it's this one.
Okay, I think that's the same one too.
Okay. I apologize. Sorry.
Here's another one.
So, so I will mark this as Plaintiff's Exhibit 2, which is the financial document. I just needed to see either the electronic transmission or evidence of a check or money order. Okay. So June 22nd comes and goes. What happened?
So I kind of like was trying to check in about it, and then I ended up having my mom message him just because nothing was going anywhere between the two of us about it.
So let me ask you this, just so I'm clear. Did you say to him, you need to pay me back?
Yeah.
Okay.
A lot.
All right. So you told him you
Yes.
agreed to pay me in June, and you weren't getting anywhere with him.
Right.
Okay. That's because one of the things in Ohio law is you have to make a demand.
Yeah.
You have to make for your money back. Okay. So you did that, and you tried to contact him.
Yes.
Then you had to get your mom involved.
Yes. So my mom messaged him, and I'm currently pregnant with his child, so that was what led to this kind of, because he didn't have a job or a car, so he told me that if he could buy a car, then he'd be able to get a job. So that's what led to me giving him the money for a car.
Mm-hmm.
And then after I continued to ask for the money, He claimed that he would not give me the money until I got a paternity test, which was never in our original
Part of
agreement.
any of this.
Exactly.
Okay.
So that was also what kind of led to me getting my mom involved, because
Okay.
that's what he kept.
And so then your mom got involved.
Yes.
Let me just ask you the simplest question.
Mm-hmm.
Has he paid you anything?
No.
Okay. And just want to make sure that there's no partial payments or anything involved. So you've tried and tried to get the money
Yes.
back. You've gotten nothing back.
Right. And he tried saying that he has the money, but that he wouldn't give it to me unless I got this paternity test.
Okay.
So,
Do you have anything else you would like to say?
I think that's everything.
Thing? All right. Would you like your witness to testify? Or do you think you've got enough here?
I mean, I think everything that I said was what I was going to
Gonna
ask her.
Anyway.
And it's kind of shown in the messages, like, between the two of them, so.
Yeah, okay. And that's your plaintiff's exhibit 1, right? And, all right, well, did she get her instructions? Okay, so here's how it works. I will issue a written ruling. It comes through the mail. Still current address? Okay. If you disagree with the ruling of the court, you receive instructions that give you your options of what you can do if you disagree. Cases are, the rulings come out in the order in which the cases are heard, okay? It may look like it in here, but you're not my only case,
Yeah.
all right? I have many, many, many more in front of you that I've heard that I write the decisions. So it may take as long as 4 to 6 weeks
Okay.
to get it, but it's going to come out in the order, same order
Okay.
as the cases. So you'll get it as quickly as we can get it, the paperwork out from the court, and you'll get it through the mail.
Okay.
Do you have any other questions about what's happening today or what's going to happen in the future?
I can't think of anything right now. I feel
All
like
right.
maybe once I get that in the mail and look it over, I don't know.
Yeah.
I will, but
Okay. Yeah, all right. So I just want to make sure that you understand fully the process. All right. Then this case is over for today, and you're free to go.
okay, thank you.
Mm-hmm.
Miss Silver, will you unmute, please? I can't hear you, Miss Silver. You need to unmute. There you go. Thank you. Hey, so I have Brandy Kelly's calling in. She's trying to connect the audio. So we're going to wait a minute here, see if we can get her connected. I don't think she's having luck. There we go. Miss Kelly looking for some audio. I don't know if she can hear me. She's trying.
Hello?
Brandy Kelly?
Yes, this is she.
Now, how are you? I'm Gino Solomoni. I'm the judge in this matter, and I have Pamela Silva here. Miss Silva, would you state your name?
Pamela Silva.
Thank you. And Brandy Kelly. So the first thing you have to advise both of you is that this is a small claims matter. If you continue with today's hearing, you're waiving your right to have an attorney, waiving your right to have a jury trial, waiving your right to seek beyond damages in the amount of in excess of $6,500. And my decision would be final. There's no appeal for my decision. Each of you have the right to say, Judge, I want to have this matter heard in the district court. It's called an order of removal, and it'll be treated as a regular case where I have a right to an attorney, a right to appeal, a right to a jury trial. Ms. Silva, do you understand your rights?
Yes.
Do you want to proceed today?
Yes.
All right. And Ms. Kelly, you understand your rights?
Yes, I'm having a problem with my microphone. Trying to get my voice.
It's okay with the camera as long as you can hear me and I can hear you. We're okay. But
Oh, there we go.
Ms. Kelly, you
No.
understand? All right. Ms. Kelly, you understand your rights, correct?
Correct.
And you're not driving, right?
Correct.
Okay. And you want to proceed in today's hearing, or do you want to go to district court?
No, I'll proceed.
Okay. So with that in mind, Ms. Kelly, I'm going to ask you to raise your right hand. You swear or affirm to tell the truth and nothing but the truth to help you God.
I do.
So this is about you. You were in a car accident, right?
Correct.
And you had insurance on your car.
Correct.
And I want to ask Ms. Silva. I'm going to ask you to raise your right hand. You swear or affirm to tell the truth and nothing but the truth to help you God.
I do.
And you had insurance on your car, correct?
Correct.
Ms. Kelly, you were paid $3,000
Yes,
by
sir.
the insurance company, and that was from Ms. Silva.
Correct.
Okay. My understanding of the law is that would be all that you could collect at this point in time. Do you have any
No.
law? Do you have any law that says it's different?
Well,
Go ahead.
my State Farm agent instructed me I could still collect another $3,500 per the law if I chose to.
Yeah, I have to disagree with your State Farm agent. So see, that would have, what he's saying is that takes you to 6,500 under mini tort, but all I have claimed here is you're claiming, the damages for the car have been paid, and that's what the law limits you to the $3,000 related to the property tax on the car. The pain and suffering from your hand is healed, I take it?
It is. I had to pass a new job up for it, but yes. When I was hit, I was working for DoorDash at that time. I was actually working that day, and I could not do that any longer due to that. So I was off work for a long time, got offered another job at another company, and was not released from work to take that job. So it's caused a lot more than just a broken car.
Yeah, but not enough, I think, to get us to the serious impairment standard required by law. So I'm going to have to just indicate I'm dismissing your case at this point in time because you're paid the $3,000 and mini tort law bars any further action.
I thought you may do that because of her community involvement. That's okay. Thank you for your time. Have a wonderful day.
Okay, I have no idea what you're talking about. I'll be honest with you.
I don't either.
I'm sure you don't. Her husband's a doctor. It goes pretty far. Bye-bye. Bitch.
Hey, that's enough. You want to be in contempt of court, Brandy?
Nope. I'm getting off the phone.
Huh?
Thank you. Have a great day.
Yeah,
nope,
no, you should come into court. Then we can hold you in contempt.
Okay. I didn't say anything to you. I'm talking to somebody in my vehicle, so I'm trying
care.
to get
No,
off the phone.
Know better. You know better. Don't go there. You know a lot better. You're a grown adult. Now so you should hang up before I order you to come into court, and then we'll hold you in contempt. So hang up your phone and be quiet about it.
Fuck you, asshole.
Ah, there we go. Come on in, Miss Kelly. Hey, Miss Sylvia, what are you going to do?
I'm sorry.
It's outrageous. So we'll see. Take care.
Thank you very much.
Thank you.
What's the bankruptcy situation of 24-hour fitness at the moment?
24-hour fitness emerged from bankruptcy. I want to say it was December 31st. Might have been the 30th of 2020.
I see. Okay. So could you raise your right hand, please? You swear and affirm the testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. And then, well, actually, yeah. How is it that 24-hour fitness owes you $200?
So, Judge, the short recap, I joined 24-hour fitness when I moved to Olympia in 2006, kind of a lifetime membership thing. I paid every year a yearly dues for 15 years until 2020. In 2020, COVID hit, and the manager of the club, 24-hour fitness Olympia, told me they were going to be closing the club because of COVID, which I understood at the time. I asked her, well, I paid my yearly dues with a credit card. Could I get a refund on that? She says, well, if we don't open, you'll get your refund. I didn't know what the plan was for the club at that time. In June of that year, three months later, I saw online that 24-hour fitness was going to be closing the Olympia location. But as I went back to the Olympia location, there's no one left to talk to. They had closed the doors. So I asked for a refund, and I think there's a letter in my file from somebody from 24-hour fitness under one of those headings that says you don't need to do anything. kind of keep calm. We're glad you're a family member. We're going to work this thing out. So I called the number that was listed, and they said in order to get a refund, I had to file through this bankruptcy claim, which is included in there. And I thought I was doing the right thing by doing that. At the end of it, they said, well, we'll offer you a $25 gift card that can only be spent at 24-hour fitness, or you could continue your membership at a location. At that time, there was a location in Vancouver, Washington. I think there was one in Tacoma, but when they just looked it up in mediation, there's one in Seattle. That's the only one around here now, that she said. So, Judge, Your Honor, to me, it all falls back to my first page, my contract I signed with 24-hour fitness, which has a bunch of stipulations if I want to get out of being a member at 24-hour fitness, how I make the payments, or I need to continue to make payments. I just can't stop. But also in there, there's one piece in that under 6H that says 24-hour fitness cannot transfer your membership under a permanent club closure or move. The agreement ends 30 days. As such, you will have to pay no further dues, and you will be refunded your unpaid dues. So they closed in March. They hadn't filed. It doesn't say unless we file for bankruptcy. It doesn't say unless we close for some other circumstances. It says you'll be refunded your money. I'm not trying to gouge 24-hour fitness out of a ton of money. I just think as a loyal member for 15 years, family member that I signed a contract with, their contract, my obligations to that contract were met, and they were expected to be met. They had an obligation under that contract also, and they shouldn't just be able to say, well, we filed for bankruptcy, so we're not going to pay you back.
Well, and again, I'm going to hear from Mr. Reber. Sometimes when people go through bankruptcy, I'm not allowed to do anything after that.
Yeah,
And so, but I'm going to hear from him if you're done. Are you?
Well, I'd just say my only argument is when they closed, they weren't under bankruptcy.
Right.
And at that time, I asked for a refund of my money, and I was told to be patient. I would get it.
Right.
But
okay, let me hear from him.
Yeah.
And that may be an unfortunate reality that once they go through bankruptcy, again, I'll hear from him. And then we'll go from there. So is it Reber?
Yes, Your Honor.
Raise your right hand, please. You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. I'll hear from you.
So, thank you, Your Honor. In March 2020, everyone knows, about the pandemic and what was going on.
I were in video and not in person.
Yep. Still feeling the effects. The location that plaintiff used was closed in March, and part of this is I think irrelevant to the bankruptcy, but everyone thought this was going to be a temporary closure, a 2-week whatever situation, and depending on the state or municipality, that went into months and months. So that March was the date that the clubs closed. In June of that same year, 2020, 24-Hour Fitness filed a voluntary petition for Chapter 11 relief in the U.S. Bankruptcy Court in District of Delaware. In that process, there was a court-approved reorganization plan, and as part of that, unsecured creditors were asked to submit claims like plaintiff did, and he did submit a claim for $200 through that court-approved reorg plan, and he was awarded a $25 gift card, which is what the relief he should have been awarded through that plan.
So you're saying that his claim was dealt with through the bankruptcy?
Yes, Your Honor, and I recognize his frustration, but 24-Hour Fitness is obligated to follow that court-approved reorganization plan and bankruptcy process. And like I expressed to the media, I wouldn't waste the court's time or plaintiff's time or my time for over the nominal amount if there was another option. But like I said, we're obligated to follow that process.
Mr. Glebe, anything further?
Just, I would ask the honor to look at the contract, and it says I'll be refunded my money.
Right.
Doesn't say unless they file for bankruptcy. they closed in March. The bankruptcy wasn't filed till June or July or August that year. So from March to whatever, I should have been had the opportunity to have my money refunded.
And
So-
if I can,
Go
Your
ahead.
Honor, you know, if there was a refund due, you know, at that time, plaintiff he would have become an unsecured creditor, you know, as part of that bankruptcy.
I understand all that.
Okay.
So, Mr. Glebe, you know, everything you say is true in terms of when this happened. They were not in bankruptcy, then the COVID hit, and then they did go into bankruptcy. You submitted a claim, an unsecured, which you were at the time, and then that claim gets dealt with. And then obviously it wasn't dealt with to your satisfaction. I certainly understand why. You got a $25 gift card for $200 that you were owed for the entrance fee. But the reality of it is that's why people go through bankruptcy, is so they can, you know, they can deal with these things. And if debts get discharged, then there's just nothing to be done about it. And so, which is not a very satisfying. I mean, that's how bankruptcy works, and that's how which can be frustrating to guys like you. And I can tell you're frustrated because I think you can tell where I'm headed with this. But once that you submitted a claim, that claim was dealt with in the course of the bankruptcy proceeding. I can't go back and now that they're out of bankruptcy, once the debt's dealt with in bankruptcy and it's discharged, that's the end of it. You can't go to a different court and get relief. And so I'm going to decide for the defense here. And the other thing, just another thing about bankruptcy, which is why I asked that question in the first place. If they were still in bankruptcy, you know, I couldn't even hear it. This case that would just been the end of it. You just have to go deal with this in bankruptcy. You know, all debt. I mean, there's rules and stuff, but everything just stops once you hit bankruptcy, and then that's just the reality of it. So I'm sorry. I can tell you're frustrated, but like I said at the beginning,
I'm disappointed that I have to sign the contract and meet the obligations, but they don't. They're still a functional business making money. And
no, I understand all that, but like I say, that's why, for right or for wrong, that's why bankruptcy, the reorganization, Chapter 11 exists, as people can. A thing happened, a big thing that had a huge effect nationwide on all kinds of businesses, big and small. And people dealt with them in various ways. Some businesses shut down, never to reopen, where debts were gone. They're never recovered there. Some people, as apparently 24 Hour Fitness did, go through a Chapter 11. They did a reorganization. Apparently the court approved a plan to distribute or take care of the unsecured creditors. You were part of that. And, you know, I can't go beyond what was in there. The federal court's is a little bit bigger than just little old me here in small claims. But that's it for today.
Okay,
You're free to go.
Thank you for your time.
You're welcome. And you're free to leave the Zoom call there, Mr. Reaver.
Thank you, Your Honor.